This webinar offers closed captioning. To enable closed captioning, click on the live transcript button on the bottom of your screen and choose your preferred method. Welcome to the Chicago Department of Business Affairs and Consumer Protection webinar. Please note, any website or email that I mentioned will be posted in the chat. For those seeking business license assistance, you can visit the Small Business Center here at City Hall or call 312-74-GO-BIZ. Also, business license can be applied for or renewed online at chicagobusinessdirect.org. If you are a part of the BACP Entrepreneur Certificate Program, you can get credit for joining this webinar by sending an email to bacpoutreach@cityofchicago.org. To learn more about this program, please visit chicago.gov/business education. This webinar is being recorded and will be available at youtube.com/Chicago BACP. We would like to encourage all attendees to ask questions. This will be an interactive webinar. You can either raise your hand and you will be taken off mute, or you can put your questions in the chat box. Please note that the views, information, and opinions expressed during this webinar are solely those of the presenter and do not necessarily represent the official policy or position of the Department of Business Affairs and Consumer Protection or the City of Chicago. At this time, I will now turn this webinar over to Ms. Esther for us to begin.
Well, hello, welcome. Thank you all so much for joining us for this session on trademark law and branding. I'm Esther Barron. I'm the director of the Donald Pritzker Entrepreneurship Law Center at the Pritzker School of Law. And that's an academic center at the law school where we not only have a lot of classes for law students focused on entrepreneurship and innovation, we have a clinic where we represent real live clients and provide workshops and office hours to entrepreneurs throughout the city of Chicago, like we are doing today. So we really appreciate the time that you're spending with us this morning. I'm here with my colleague, Darren Green. Darren, if you'd like to say hi.
Esther, and we're looking forward to chatting with you today.
Fabulous. So we're here to talk about trademarks and branding. So as we're talking about trademark law, I encourage all of you to think about your own brand. So if you're running a company now or thinking about starting a company, your brand is protected through trademark law. So thinking about what your actual brand is as we're giving you examples and talking about the law could be helpful and make it feel a little bit more real world. And as you know, we all know, brands are valuable to businesses. If you think about companies that we're all familiar with, like Nike or Starbucks or Coca-Cola, one of the most valuable assets those companies have is the brand. If Nike had to stop calling their shoes Nike and couldn't put the swoosh on the shoes anymore and had to call it something totally different that customers didn't recognize, the value of the company would go down significantly. So thinking about how to protect your brand early is really, really important. And we all know as customers and consumers that we have our own brand loyalty. When you go to the store, you may have a certain shampoo or a certain water or a certain paper towel or laundry detergent that you have brand loyalty to. So again, another reason why protecting your trademark is so important. And when we talk to entrepreneurs and business owners about trademark law, we like to think about it from an offensive and defensive perspective. So first of all, you want to make sure that you come up with a mark that is entitled to strong trademark protection. And that's the offensive side. You want to be able to stop someone from using a mark that's similar. So you want to make sure you have strong trademark protection. And from a defensive perspective, you want to make sure you didn't pick a mark that's infringing on somebody else's pre-existing or prior trademark rights, in which case they could send you what we call a cease and desist letter and require you to stop using that mark. And so that's what we're going to be talking about today. I'm going to be starting with the strength of the mark. How do you pick a strong mark? And then Darren's going to speak about how you make sure or try to make sure someone else doesn't already have rights in that mark. But before we get started, I just want to make sure everyone that we're all on the same page on what a trademark is. So I mentioned some of the companies and their brands. Those are examples of trademarks, but a trademark is any word, name, symbol used by a manufacturer to identify their goods or services to distinguish them from others. And trademarks can even be slogans. So shapes, colors. So if you think about McDonald's, McDonald's, that word is a word mark. The golden arches, trademark also. I'm loving it. The slogan also protected by trademark law. So really, it's pretty broad how you brand your business so that customers recognize that when they see McDonald's or see the golden arches, they know what they're getting. And so with that said, a little bit of history on trademark law, although, as I mentioned, it's very valuable to businesses, it's actually it comes from a consumer protection perspective. We want consumers to be entitled to have their expectations met. So if I were driving on a highway and I saw golden arches in McDonald's and I stopped and I had a certain expectation, whatever that expectation might be, of what I'm going to get, we want that to be met. So if when I get my French fries, they're not the delicious, skinny, salty French fries that I expect, and instead there's something totally different, and then I look more closely, and although there was golden arches and there was the script of McDonald's, it actually said McDougal's, as you might remember from a movie, I've been tricked. So I didn't get what I was expecting. So that would be a trademark infringement case against McDonald's, but it would be because I was actually confused and tricked into purchasing something that didn't meet my reasonable expectations. Okay, so let's start with just how you establish trademark rights and how you choose a mark that's strong. So one thing to keep in mind, as soon as you start using your brand name or your slogan in connection with selling your product or service, you're creating what we call common law trademark rights. And so you may have noticed sometimes there's a little TM next to a brand and sometimes there's a little R. The TM, you're entitled to use right away. And that's putting the world on notice that you are claiming trademark rights into the particular brand that you're using. You don't have to do anything else. You don't have to file anything. You don't have to pay any fees, which is great. The downside is you only get through common law trademark rights, the limited protection in the limited geographic area where you're actually running your business. So if you're running your business in Chicago, you'd be limited to this geographic area. If you want federal trademark rights, and Darren's going to talk about this in a little bit, you need to register or apply to register your mark with the United States Patent and Trademark Office, and then you get to put the little R next to your mark. Okay, so how do you even know if you've chosen a name or if you're still thinking about a brand? How do you choose a name that in a vacuum? So not thinking about what any other rights that other people might have, just how do you choose a mark that would be entitled to strong trademark protection? And I'll start by saying if you choose a generic word, there's no trademark protection for a generic word. So if I were starting, let's say, a water company and I was selling bottled water and I called it my product water or H2O or agua, I can never get trademark rights in that generic term. So now let's talk about the types of marks that are entitled to trademark protection. The weakest type is what we call descriptive. And descriptive marks are not entitled to trademark protection immediately, but if you acquire what we call secondary meaning in the market, and I'm going to talk about what that means, you can ultimately claim and get trademark rights. And so a descriptive mark is just what it sounds like. It merely describes the product or service. So sticking with water, if we were to think about vitamin water, it's just water infused with vitamins. Initially, that mark would have been considered descriptive and not entitled to immediate trademark protection. But as we all know, they've spent lots and lots of money on advertising and marketing, and we all connect vitamin water, the brand, to that specific product, which is what we call acquiring secondary meaning in the market. So they are able to now have strong trademark rights in that brand. You can imagine lawyers don't love descriptive marks because it takes a little bit longer, more time, more money to acquire trademark rights. But sometimes business people do like and are attracted to or drawn to descriptive marks because without spending any money on advertising, their consumers know what their product or service does. Like if you saw vitamin water before you'd ever even heard of it, you'd kind of know it was water with vitamins in it. Where lawyers and business owners sometimes can compromise is on what we call suggestive marks. So suggestive marks don't merely describe the product, but they suggest something important about the quality or character of the product or service. So sticking with water, if you think of the brand Ice Mountain, it's not ice from a mountain, obviously, but it does suggest, if you were hot and thirsty and you saw the brand Ice Mountain, that would be a cool, refreshing drink. It suggests something about the product. And that's also helpful to business owners as they're marketing their product. And from a legal perspective, it's entitled to immediate strong protection. The strongest categories of marks are what we call arbitrary and fanciful. Arbitrary marks are marks that they have an ordinary dictionary, a real word dictionary meaning, but that's unrelated to the product. So if you think about a very obvious example, apple, if I were selling fruit or apples, it would be generic and I couldn't get any trademark protection. But when I put it on a computer or a phone or any sort of a tech device, then it's really strong protection. It's not at all related. The meaning, the dictionary definition is not at all related to the product or service that I'm attaching it to. And the strongest marks are what we call fanciful marks. And those are just totally made up words. They don't have any meaning before a company or a business starts using it in connection with marketing their product. Years ago, I had a handbag company. I've closed it down, but I ran it for a long time. And our brand was Elazar, E-L-E-Z-A-R. Totally made up word. It was a combination of my first name and my business partner's last name. And those made up words are entitled to the strongest trademark protection. Again, from a business perspective, sometimes that's a little bit less attractive because it's a word nobody's heard of. So until you spend some significant money marketing and advertising, your consumers really don't know what that brand refers to or what the product or service does. So again, just a quick refresher on the strength of trademarks. Generic, no trademark protection, can never get trademark protection in a generic word. Descriptive, the weakest type of mark, and they are not entitled to immediate trademark protection, but you can ultimately get trademark protection when you acquire the secondary meaning in the market. Suggestive marks that suggest something about the product, but don't merely describe the product or service. A nice compromise between getting, the lawyers having trademark strength and the business owners who want to communicate something to their customers. And then the strongest marks, arbitrary and fanciful. Arbitrary, the unrelated word, and fanciful, the totally made up word. It looks like maybe we have a question in the chat. Nope. Just wishing everyone a happy Friday, and I will wish you all happy Friday as well. And with that, I will pass it over to Darren. And again, please, you can jump in with questions. You can put them in the chat, whatever is the easiest, but we want to make sure that this time is useful to all of you. That is our #1 goal.
All right, thanks, Esther. I'll sort of reiterate, we love questions and we love well wishes for Friday as well. We love all of it, but feel free to add your questions to it also. Those are sort of fun. So I want to sort of build off of what Esther was talking about. Esther sort of started at the very beginning, talking about sort of the offensive and defensive approach to thinking about trademarks. And so I want to talk a little bit more about that. So let's say you're in a situation where you've gone through the analysis that Esther just described. You came up with a name and you've decided it falls within one of the good categories: suggestive, arbitrary, fanciful. So your mark is strong enough to get federal trademark protection. The next thing you want to think about is, okay, I know my mark meets that test, but what happens if there's others out there that were using the name that I just came up with that I like so much? Let's say they're using it before I started using it. Maybe they've got prior rights, better rights already in this name. And so if I start to use the name, even though it's kind of a strong name, I might get one of those nasty letters that Esther mentioned, cease and desist letter, which is basically a letter from a different owner of a trademark or their lawyers, asking you not so nicely to stop using the mark, cease and desist, right? Because they have trademark rights and you're potentially infringing on those rights. So we don't like those letters. We want to avoid those letters. We want to be able to play defense. So should we get such a letter, we can kind of push back and say, no, we've actually got trademark rights in this name, so we don't have to stop using it. So how do we do that? How do we set ourselves up so we can play that defense? Well, we start by we run trademark searches. And we'll talk about how we run those trademark searches in a moment. But at a very high level, when we run these trademark searches, we're looking for any other uses of our brand or our tagline or our logo, whatever it is that we're trying to establish trademark rights in. And we want to see, is anybody else using this? And if anyone else is using it, have they gone to the trouble of filing for federal trademark protection so they could use that little R with the circle that Esther mentioned? Because if there is somebody else using it prior to me in a way that would be confusing with my use, I might want to think about a different name because I'm sort of asking for trouble if I pursue that name. So before we talk about the searches themselves, let's talk about what we're looking for. The test in trademark law sounds very simple. When we're comparing two marks or two brands to each other, the test to determine if there's trademark infringement problems is likelihood of consumer confusion. In other words, if I use my brand name that I came up with, will it be likely to cause confusion in the mind of the consumer relative to another brand which is already established? Will they confuse the two brands and think that maybe they're owned by the same company? Are we sort of misleading consumers? So that sounds really easy. It's 4 or 5 words: likelihood of confusion, mind of consumer. Unfortunately, as is often the case in the world of intellectual property, it's not so simple to actually use that test, to deploy that test. Likelihood of confusion can mean lots of things. One person might think there's a likelihood of confusion between two marks. Another person may disagree. There's no sort of single correct answer sometimes. But courts, when they're looking to determine whether there's a likelihood of confusion between two marks, will often look at certain factors. So we can at least identify those factors so we know how to evaluate. The first thing we would look at is the marks themselves. How similar are they? A court or anyone, the USPTO, the United States Patent and Trademark Office, anyone evaluating two trademarks, they're going to start by looking at the marks. If they're an exact match, Esther mentioned McDonald's. If I launch a company called McDonald's, right, that's an exact match. So that would be a strike against us if the marks are identical. Now, bear in mind, sometimes we'll have clients come to us and say, okay, we found in our searches another trademark which is identical to ours. It's the same words as the branding that we want to use. So we're just going to add a "the" in front of it, or make ours plural, or maybe use like the newfangled text spelling and get rid of all of the vowels in ours. And they'll sort of say to us, that'll take care of it, right? Because we're no longer an exact match with this other brand name, which is already out there. And while we'd like to say that solves the problem, unfortunately, it doesn't. It's sort of sight, sound, and meaning. Marks that have an S to be plural or have a "the," that's not going to change your mark usually enough to differentiate it from the other mark. The consumer would still, in looking at your mark, be confused with the other mark, even though the marks aren't identical. The marks have to be far enough apart that a consumer wouldn't reasonably think that one brand and the other brand are sort of owned by the same company. So changing your mark a little bit often isn't enough when you find an exact match. Even marks that are sort of close, that's enough often to create confusion and hence potential infringement. So that's the first thing we look at. How similar are the marks? The next thing we look at is the similarity of the goods or services covered by the brand. When you get a trademark, if I get a trademark over green tire repair, to use my last name, I'm not very creative, and somebody else is using the name green restaurant, Well, there's a reasonable chance that a consumer wouldn't look at my green tire repair and that pre-existing green restaurant and be confused. They're entirely different businesses. When you get a trademark, you don't sort of own the name itself, subject to certain exceptions, which Esther will talk about in a moment. You generally don't own the name itself. You have rights to that name in your line of trade, in your business. So a court or the United States Patent and Trademark Office would not only look at the names to see how similar they are, the brands, they're going to look at what business is associated with the brand. If those businesses are entirely different, you may be okay even having the same name as a previously existing brand. If they're similar, you may have trouble, right? So that's another prong in the test to determine likelihood of confusion. Then we get into some of the more kind of nuanced tests. Those are the two main tests. How similar are the brands? How similar are the businesses covered by the brands? The next thing we may look at is sort of target consumers. Is one brand going after certain consumers and another brand going after a different basket of consumers? They'll look at that. They'll look at actual confusion if they're evaluating whether or not that there's infringement. Is there evidence that consumers have actually expressed confusion? Maybe they've written a letter to one of the brands saying, hey, wait a minute, are you the same as this other brand? So that's a good indicator that there's likelihood of confusion when there's actual confusion, if we've got evidence of it. So if there's actual confusion, we'll usually find that there's a conflict between two marks. And finally, courts or the USPTO will look at intent. If it's clear that one party was creating a brand to try to benefit from all the work done by a previously existing brand, like they had sort of this malicious intent. They were trying to be sneaky and create the same name so they could benefit from all of the goodwill created by the previous brand. That's going to be part of the test as well. So when we're looking for trademark infringement, likelihood of confusion, those are the 4 or 5 tests that we're generally going to try to have in the back of our mind when we're evaluating, when we run searches and we're evaluating whether there's a likelihood of confusion. Those are the tests we're going to have in mind. So how do we run these tests? What do we do to get comfortable that we can play defense? We're not going to get cease and desist letters from a bunch of other previously existing marks. Let me start by what isn't a good trademark search, because there's sometimes confusion around this. Number one, sometimes companies or founders will run searches with the Secretary of State. So, when you form your business, you create an entity, there's a filing you make with the Secretary of State. When you do that, you go into the Secretary of State records with the name of your entity. So whatever, many of you probably have entities for your businesses. So sometimes founders will go to the Secretary of State, let's say you're formed in Illinois, and they'll search the Secretary of State records in Illinois to see if there's other entities with the same name. It's a good fact if there isn't another entity with the name of your brand, but that's not trademark law. That goes only towards the name of the entity itself. Trademark law is sort of establishing rights in your brand nationally, sort of across the United States typically. So Secretary of State searches are not adequate to determine whether or not you're going to have a likelihood of confusion. What else isn't adequate? Domain name searches. So sometimes founders will get the domain name for their mark. And they'll say, okay, well, if I got the domain name, I must have adequate trademark rights because, look, I can launch a website under this URL that I've wanted. That also isn't trademark law, and that also isn't a trademark search. Someone else could have a domain name, but be using it for something entirely different than your business, and there wouldn't be any trademark conflict. So it's great from a business perspective to get the URL you want for your business, but you can't sort of hide behind that shield and say, well, I've got trademark protection as well. What else isn't a trademark search? Getting social media handles. So you might run searches in Facebook and Twitter and Snap and all the other services that I don't use. And you may feel like, okay, I've got all these social media handles. I must have trademark protection. Again, just like domain name reservation and searching Secretary of State records, that's not adequate. Those are all great for your business to get those things, but they're not from a legal perspective. They're not adequate to a sort of established trademark protection. So we've talked about what isn't adequate. What is adequate for a trademark search? Well, there's two things you'll typically do. One of them is quite easy, something you probably do every day. Go to Google or Bing or your search engine of choice and run a bunch of searches over your brand. Change the spelling, change the name. Again, they don't have to be exact matches. Get rid of the vowels as we talked about. Be as broad as you can and just get a lay of the land on Google or Bing or whatever you're using to search. You'll pull up lots and lots of search results, obviously in a Google search. And so that'll be a good indicator. Are there other companies that are similar to mine using a similar brand or logo to what I'm using? So that's a good place to start. But if we want to pick up the most dangerous pre-existing trademark rights, in other words, those that are most likely to create problems for us down the road, we want to run searches for federal trademark registrations. And we do that at the United States Patent and Trademark Office website. If we go to uspto.gov, they've got a little trademark button. And if you click on that, you can wend your way to a search button that looks just like the Google search button. And we want to run searches at the USPTO website. And what that's going to pull up from their database are other federal registrations or trademark applications which are similar to our brand. We want to be as broad as possible. We might end up running 40 or 50 searches at uspto.gov. Because again, it doesn't have to be an exact match. So if we've got a 4-word mark, reverse the words, get rid of some of the words, only use 2 of them, change the spelling, make them plural, make them singular. Think of words that are similar. We want to run searches over all of those to try to unearth any possible mark which might conflict with ours. So uspto.gov, it's uspto.gov. That's the United States Patent and Trademark Office website. And you'll see they've got certain tabs that are related to patents, which is a whole separate thing that we're not talking about. And then they've got a button for trademarks. And you want to click the trademark button when you go there. And someone just put it in chat. Thank you. Helpful. So those are the 2 places we're going to search. So these are what we call knockout searches. When we run searches on Google and we run searches at USPTO. So now we're going to come up with, these days, it's very rare to run searches and come up with nothing. There's no other brand similar to ours. That's what every founder wants. And then they run the searches and they get progressively sadder and sadder as they run them, because brand names these days, there's somebody doing something with some similar brand. Yes, they're repeating the generic descriptive, the categories. I'll just repeat them quickly to not pull Esther back in. There's strength of mark, there's generic, which is not entitled to any trademark protection. There's descriptive, the weakest, not entitled to immediate trademark protection. Then we get to suggestive, which is in the good category. Then we get to arbitrary, really good category. And then we get to fanciful, made up words, the best from a trademark perspective. So those are the 5 categories to answer your question. So going back to the searches, we're going to find something similar to our marks. So sometimes founders will get hundreds and hundreds of responses, hundreds and hundreds of other marks that look sort of similar, but there's no exact match. So they'll say, well, if there's a crowded field, so to speak, there's lots of noise around this mark, there's lots of search results, none of which look like they might be direct infringement or conflict with ours. What we'll often tell clients is, you may be able to get your mark. Maybe you can navigate through this sort of maze of other search results which came up, but your mark might not be that strong at that point. If there's lots of other users of a similar brand to yours, even if there's no direct conflict, it may be hard for you to establish your own little corner of the universe because there's so many other uses which are close to yours. It may be hard for you to get sort of strength in your mark. So when there's lots and lots of other uses, sometimes founders will think about picking another name, even if they could find a way to get that trademark protection. This is sort of the difference between offense and defense that Esther mentioned. If you get the mark, you might be, if you get a federal registration, you might be able to play defense, because if someone sends you a cease and desist letter, you could sort of waive your federal trademark protection notice and say, look, I've got a federal trademark. But let's say you want to play offense. You want to stop somebody else from using a confusingly similar name to yours once you've launched your brand. If there's lots of other uses out there which are similar, if you send a cease and desist letter to somebody else, it's possible they're going to push back and say, look, there's a dozen other companies using the name in a similar way to yours. I don't think you have strong rights in your name. I'm not going to stop using it. So when there's a crowded field, when there's lots of other search results that's come up, we want to think about changing our name. Once we find one that we think meets the test, there's no likelihood of confusion. There's no pre-existing registrations which look like they're going to present trouble. Then we want to go ahead and get the trademark ourselves. Esther mentioned you get certain trademark rights just by virtue of using the name, right? If I just use the name in commerce, I get what's called common law trademark rights. But if we want the strongest trademark rights, as Esther mentioned, we want to register with the very same USPTO where we just ran our searches. They've got a different button on their website, not for searching, but for filing trademark applications for federal trademark protection. You can do it right at the USPTO website. As intellectual property goes, it's not all that expensive. It's usually around $250. That's the filing fee they charge, assuming you file in a certain way. So if the budget permits $250, you can do it right at the website. You fill in some information. They'll often work with a lawyer, although it's actually not required. Founders can file themselves if they feel comfortable doing it. You can watch tutorials at their website to learn how to file a federal trademark application. If you have a lawyer and you work with a lawyer, not a bad idea to use that lawyer. Just in case there's problems with the application, someone who does this kind of work can help navigate you through. And hopefully you come out at the other end with a federal trademark registration. You can use a little R with the circle on it that Esther mentioned. You can then play defense and offense. The last thing I'll mention before I turn this back over to Esther to talk about a couple of sort of exceptions to things we've been talking about. There's no such thing as a 100% effective search. So clients will often want to run these what we call knockout searches, trademark searches. And what they'll want at the end of the process is confirmation from their legal counsel that there's a 100% chance they won't have any issues. They won't get cease and desist letters, and if they file for registration, they will get the trademark. Unfortunately, we're not in a position to do that. There's no such thing as getting 100% certainty in a search. There's always uses of a brand that you might not think of, or spellings that are strange enough that they don't come up in any of your searches. Sometimes things slip through the cracks, and you end up with a mark that you didn't find that pops up later, or the USPTO, when you file for trademark protection and they run their own searches, they find it later. There are companies out there that will run searches for you. Thomson is one. There's a variety of companies out there. They've got access not only to USPTO and Google, which you also have access to. They have access to other databases that they work with. They might subscribe to other databases, whether it's Yellow Pages or whatever it is. So they'll generate these fancy reports. They used to be bound reports. Now they're virtual reports that they'll email to you, which are maybe more thorough than the reports that a lawyer, a founder would generate. So you can do that if you want. The problem is they charge for those services, and they charge a fair amount. A search can cost $750, $1,000, depending on the search for each search. most founders don't want to devote thousands of additional dollars to their searches. They don't have the budget for it. So while it would be nice to use these companies, the vast majority of founders will work with their legal counsel or do it themselves and run these Google searches and USPTO searches. They'll get as much comfort as they can, and they'll sort of go from there. So that's searching, what we're looking for, likelihood of confusion when we search, how we establish trademark rights through federal protection. I know there's a bunch of questions, but before we get to them, I want to turn it back over to Esther. She's going to talk about a couple of exceptions or little nuances related to things we've already discussed.
Thanks, Darren, and thanks everyone for all the great questions. I've been kind of frantically trying to answer some of the questions in chat and in the Q&A. But if you didn't get your question answered, like Darren said, we're going to save time at the end. So I don't want to forget, though, I did put in the chat, Darren and I did a video on this topic with slides, because a few of you have asked, are there slides for this? In a different presentation on this, we did use slides, we recorded the video, and I put a link to that in the chat if that's helpful. Okay, so now I'm going to talk about an exception to what we've talked about so far, and that's if you use a famous mark. So Darren talked about the test being consumer confusion. So if you want to use a mark that someone else might have, rights in a similar mark, again, it doesn't have to be the exact same mark. The test is going to be, is the consumer likely to be confused by the source? The exception to that is if you are using a famous mark. So I'll go back to my example with Nike. Obviously a famous mark. I couldn't sell like Nike chocolate chip cookies, even though probably no one would be confused that this was the shoe company now selling cookies. The test is different. It's dilution. And one of the cases where this came up was a used tire company called Tiffany's. I think it was like Tiffany's Used Tires. And there's the, fancy jewelry store on Michigan Avenue and on, in other fancy places of other cities that sells expensive jewelry. And so it wasn't that anybody was confused that the jewelry store is now selling, used tires, but the court said it diluted the brand. So with famous marks, the test is different, it's brand dilution. And what we generally tell our clients is just don't use a famous mark, because those companies have a lot of money to litigate, and they are gonna most likely, almost for sure, pursue a trademark infringement, and the test is easier for them to satisfy. So that's famous marks. Sometimes people say, well, what is what constitutes a famous mark? There isn't a really great legal test for that. It's kind of, it when you see it, but things like Nike, Coca-Cola, these are clearly famous marks. Okay, so the last thing we're going to talk about is how you lose trademark rights. And we've spent all this time talking about how you get trademark rights, really like a positive, happy thing. Now I'm going to end with a sad thing, how you lose your trademark rights. But really we'll end with questions. So we'll go back to a happy note. But one of the ways you can lose trademark rights is actually a great reason is that your name becomes so widely used that it actually goes back to being generic. That's not something that entrepreneurs or business owners that are starting out are really worried about. That actually sounds like a wonderful problem to have. But if you think about companies where you start using that brand just pretty generically, they can actually lose trademark rights. So a good example is escalators, the moving staircases that we all take. That was actually a brand at one point. And because we all just refer to escalators as escalators, the generic term for a moving staircase, they've lost their trademark rights. And you can think about other businesses that are out there that are probably at risk. They haven't lost them yet, but their lawyers are thinking about it. So Band-Aid, right? Like anytime you see like a bandage, you call it a Band-Aid probably. So Johnson & Johnson, the owner of that trademark, will always say Band-Aid brand bandage. Kleenex, right? If you see, if I was sitting next to someone and they had a box of Puffs facial tissues and I said, oh, achoo, can you hand me a Kleenex? And the person said, I'm sorry, I don't have any Kleenex. I would think that was weird and rude because I could see the box of puffs and I was using that term interchangeably. Again, the company that owns the brand Kleenex is being very careful and starting to only market as Kleenex brand facial tissue. You can say the same thing with Xerox, right? Like if you're going to make a copy of something, oftentimes you'll just say, can I Xerox that? And so as these terms become so popular, you can lose trademark rights. Another way that's probably more likely is if you stop using the mark. So unlike other types of intellectual property like patents, it's use or lose. So if you're not using your trademark, you can't hold on to it and reserve it. Once you stop using the name to market your product or service, after a period of time, after a few years, you will lose those rights. You can't hold on to them indefinitely. You also can't reserve them like you can a domain name. You can file, Darren talked about filing a trademark application. If you're not using your mark yet, you can file what we call an intent to use application. And that gives you 6 months to actually show that you're using the mark in commerce, and you can ask for an extension up to 5 times, so you can get 2.5 years. But you have to have the present intention to actually use the mark, unlike with a domain name where arguably you can hold on to it before you know exactly how you're going to use it. So that's it. That's our presentation on trademark law and branding. I do want to go back to one of the questions that I know we didn't answer very thoroughly, which is, and it's an important one because I think a lot of business owners do this, entrepreneurs and business owners, is use your own name. And all of the rules that Darren and I talked about apply when you're using your own name. One thing to note, if you're using your last name, that's considered descriptive initially. So again, if you're just using your last name and it sounds like a last name, you're going to have to acquire secondary meaning. But imagine my last name was Field. It's not, it's Barron. But what if my name was Esther Fields and I wanted to start a cookie company and call it like Ms. Fields Cookies because that's my name? I actually couldn't because of all of the reasons Darren said. That would be confusing to consumers that I was part of the Mrs. Fields Cookie Company. So I would actually not be able to use my own last name. And I believe that came up in a real case with the grandson of Gucci, the designer, who had a belt company and actually couldn't use his name to market and brand his belts because it would be confusing to consumers that it was part of the actual Gucci brand when it wasn't. So again, this goes back to what I said at the very beginning. The trademark law is really to protect consumers, even though one of the benefits is obviously to create value for business owners. So with that, let's open it up to questions, and Darren and I can look and see in the chat if there's any that we've missed.
Yeah, I think there's a bunch of new ones. So why don't we sort of in rapid succession here, we'll just sort of pop through these. There's a lot of good questions here. I'll pick one. Sheila, it looks like you asked, is trademark the same as your business name? That's a very good question and a source of confusion in the mind of many founders. And the answer is a frustrating one. It depends. So, think about a business, think about Microsoft, right? So Microsoft is a massive corporation. Microsoft Inc. is the name of their business. That's the name of their entity. But Microsoft has lots of different brands, Excel, Word. Think about all the different things you use or might use from Microsoft, which are like brands. Those are all trademarks. So the name of your entity for some startup companies, or even non-startup companies, for some companies, you'll name your company the same name as the brand you're trying to protect. They're one and the same. So in Esther's example, Fields Flowers. Right? If you might have an entity called Fields Flowers Inc., and your brand might be Fields Flowers, and in that case, the name of your entity, the name of your company, is exactly the same as the name of your trademark. Or you might have Fields Flowers as your brand, but the name of your company is ESB Holdings Inc. It's just some generic name with your initials, right? Lots of times an entity name is just something that sits in the background. It's not the brand that you're holding out to the public. In that case, the entity would be named one thing, but the brand, which is owned by that generically named entity, is something different. And so you file for trademark protection against your brand, not your entity. Your entity isn't a brand you're holding out to the public. You're not looking to protect that name. It sits in the background. So Sometimes the business name, the entity name is the same as the trademark. Sometimes the entity name is different than the trademark. It just depends on the business and how they're operating. I'll let Esther pick a question.
Okay, and so I just it seems like a lot of people didn't get the original post of the video, so now hopefully everyone's gotten it. That's a link to our website. If you scroll down to the bottom of that link, there is a video that reviews all of the all of what we've just covered today, and has a PowerPoint presentation. So I'm going to pick how many. Katrina, you asked a question about how many documents, logos, slogans can I trademark in one trademark application? And that you're asking because you have a bunch, it sounds like. And so here's the answer, and that's an excellent question, and we didn't really mention this. When you apply for a trademark, you're applying for that mark in one class, and there's different international classes. And so like when I had Elazar, I applied for Elazar in the class of, you know, women's accessories, I believe. But if I were also doing, you know, besides handbags, coats or home goods, I would have had to apply in different classes. So for that same mark, if I wanted it to cover different classes of stuff or services, I could do it all in one application, but I'd be paying that application fee for every class. And I had put in the chat earlier that the application fee is about, it ranges depending on which form you use, between $225 and $350-ish per class. So in that one application, if I have, you know, 3 classes, I could be approaching $1,000 fee. I generally do one class at a time, make sure I get that class before I expand onto other classes. If you want to apply for a word mark like Elazar, but you also want to apply for a Logan or a slogan, again, it could be the same class or different classes, that I would do in separate applications. And again, you're going to be paying an application fee per class and per brand, per trademark, whether that's a word mark or a slogan or a logo. So hopefully that answers your question, and I will pass it back to Darren.
All right, I will accept the baton, and I see a question here. Can I add the TM or the little R with the circle around it to my logo before I do the trademark? Another excellent question, and something we see done incorrectly out in the marketplace with frequency. So we mentioned there's a couple different ways to establish trademark rights. As soon as you start using your brand in commerce, you're going to automatically, without doing anything else other than using your brand, you're going to get what they call common law trademark protection. It's not as strong as federal protection if you register with the USPTO, but it does provide certain protections. You can use the little TM. So when you see that little superscript TM, next to a logo or a brand or what have you, the owner of that trademark is sort of declaring common law trademark protection. That's what the little TM means. You don't have to use the little TM. You're allowed to use the little TM next to your brand. So that you can do as soon as you launch your brand and you're out in commerce. The little R with the circle around it, that's the better thing to use if you can, because that means you've got the strongest trademark protection, federal trademark protection across the country. You can only use the R with the circle around it once you have a federal registration. So we'll see founders often use that little R with the circle around it, because why not? It's the best one to use. It means you have the strongest protection, but you're not allowed to use it until not only do you need to apply to the USPTO, you still can't use it then. You have to make it through the whole process with the USPTO and have them issue a registration certificate to you. Then you can start using the little R with the circle around it. So little TM as soon as you launch, R with the circle around it, only if you get federal registration. If you never get federal registration, let's say the examiner finds a conflict with another mark, and so they don't issue you a trademark registration, then you can never use the little R with the circle around it at that point. So hopefully that answers that question. I will pass it back to Esther.
Thank you. Of course, my dog just started barking as soon as it passed back to me. So I want to answer a couple questions that I saw here. One is, how do you apply to work with us? And so there is also a link in the link that I just put in chat. There's the video at the bottom, which is our trademark search. There's also a link to our online application, and we'd love to work with some of you. The problem is, it's not a problem, but it's the way the clinic works is it's a class. So you work with law students, but it's we take clients at the beginning of each semester. We're just wrapping up our spring semester. So the next time we'll be taking new clients is actually at the end of August. So if anyone wants to apply to work with us, the next time would be the end of August. And hopefully that's helpful. There was something else. Let me see, give me 1 second.
I've got a question, Esther, if you want me to pop one in.
Okay, you pop right in.
All right. So I see a question here. I think this is more, I don't think, we can't obviously give advice on this talk about specific situations, but there is a question here about sort of metal doors. Like, what if my class was metal doors and my trademark was ABC Metal? Again, I'm assuming these are just representative example names, not sort of, we're not talking about an actual company. And nothing exists for the trademark name. So your question, taking a step back, is sort of an interesting one. So let's say you were launching a company called ABC Metal Doors, and you're going to make metal doors. We talked about Esther talked about the different classes, sort of strength of trademark. So if your mark was ABC Metal Doors, and let's say you filed for protection with the United States Patent and Trademark Office, against ABC Metal Doors, what might happen is the examiner assigned to review your trademark application, the USPTO has hundreds of examiners, and you're assigned to one when you file. They would look at your mark and they might split it in two. And what they might say is, okay, ABC, I'm going to search that. ABC doesn't seem generic or descriptive of what you're doing. And so you might be able to get strong trademark protection over ABC as it relates to manufacturing metal doors. But the metal doors part of your mark, if you include that, they might look at that and say, well, wait a minute, that's either generic or highly descriptive, right? You're making metal doors and you're trying to get protection over metal doors. And as Esther mentioned, you can't really get that kind of trademark protection. Generic you can never get, and if it's descriptive, you got to wait to really get that trademark protection till down the road. So what they might do is they might split your mark and say, we're going to make you do what they call disclaiming the metal doors portion of the mark, meaning we'll look at ABC Metal Doors, and if there's no conflicting marks and no other issues, we'll let it go through to registration. But there's going to be a little disclaimer note under your registration that says you don't have any trademark protection rights over the metal doors portion of your mark. That's descriptive. We don't want to let you protect metal doors. We're going to leave that out in the public domain for everybody to use to describe metal doors. So you're only really going to get protection over the ABC portion of your mark, even though you may be calling your business ABC Metal Doors. So sometimes examiners will kind of slice and dice a longer trademark, give you protection over part of it, and have you disclaim the other part of it because it's overly descriptive. The second part of your question was a logo question. What about having the logo, the name in the logo? You can do that. Some logos are just images without the name, and companies will seek trademark protection over that image or that picture. Other times logos are a mix between some sort of image or some sort of design and the name of the company. What we'll often advise early stage founders, because budget is limited for most early stage companies, they can't spend $20,000 on trademarks. They got to spend that $20,000 on hiring and getting customers and all those other good things. Often founders will start with just the name of their business, excuse me, and they'll go for trademark protection just over the name of their company. And then from there, maybe if budget permits, they'll expand out to their logo, maybe another logo, maybe a tagline, and they'll sort of continue to build this catalog of trademarks that they know they're going to use. So the answer is yes, you can put your name and your logo. That would be a separate trademark from just the name itself. That would be two separate trademarks, meaning, as Esther described, two separate fees. So it depends what your budget is. It also depends how set you are on your logo. Early stage businesses often start with one logo and 6 months later decide, I don't like that logo anymore, I'm going to switch it. So sometimes they'll sort of wait to make sure they're really going to use this logo before they spend the time and the money trying to, get trademark protection, only to see that trademark protection become worthless because they're going to move off to another logo. So the answer is you certainly can do it. It would be something you would evaluate sort of upfront. And I'll kick it back to Esther.
Okay, so I'm going to answer a question, but I first want to just go over this process because I feel like we've thrown out a ton of information at you. So I just want to go through what happens when you submit that trademark application. So you apply, like Darren said, maybe just for the name of your business, the word mark. So for me, for that handbag company, I would have submitted Elazar in one class, women's accessories, something like that. What happens behind the scenes? The USPTO will get your application. It will get assigned to an examiner, a person who will review the application. The first thing the examiner will look at is this mark, Elazar, entitled to trademark protection? Where on that continuum does it fall? Is it at least suggestive? And so assuming the examiner decides it's not generic, hopefully it's not descriptive. If it's descriptive, it still could get registered, but on a supplemental registry, where you have to get that secondary meaning. But let's assume the examiner says it's at least suggestive. Great, check one. Okay, it's going to move forward in the process. The next thing the examiner will do is say, are there any registered conflicts? So the examiner will search the USPTO database, similar to what you probably did before you submitted the application or an attorney did before you submitted the application, and then see if there's any conflicts that the examiner thinks would be confusing to consumers. If the examiner thinks there's a conflict or has any issues with the application, like Darren said, maybe the examiner wants you to disclaim the words garage doors or something like that, they will send you an office action asking you to disclaim those words, or maybe that they didn't think you got the right class, and you'll have to reply to the office action. Assuming the examiner says, nope, it's strong enough, the application looks good, and I don't see any conflicts, the examiner will then send you a notice that it's going to be published for opposition. Once it gets published for opposition, there's a 30-day period where anyone can contest the mark. If no one contests the mark after those 30 days are up, then the mark gets registered on the principal registry of the USPTO, and you get sent a beautiful trademark certificate suitable for framing, or at least suitable to put in your file. Just a little peek behind what's actually happening once you submit that trademark application. The question I'm going to answer is, someone asked, what if the USPTO site says it's a dead mark? Do you have to be worried? Much less worried. So a dead mark usually indicates that the company either isn't using the mark anymore, or they forgot to file something. After 5 years, you have to submit an affidavit that you're still using the mark between the 5th and 6th year. Could be someone forgot to do that. It could be that they're not using the mark anymore. When I see a dead mark, I usually do a Google search to just make sure the company really is really not using the mark anymore. But seeing that it's dead is pretty good. It's very good, much better than if you see it's a live mark, and shouldn't pose a conflict for the federal registration.
I think we're getting near time, so maybe we'll take one or two more. I see a question here. Is there any value in obtaining a trademark in the state of Illinois? And that's an interesting question. So at a very general level, when companies are thinking about getting trademarks, the vast majority of the time, what they're talking about is what we're talking about, getting federal trademark protection, meaning across the United States. Bear in mind, it doesn't cover other countries. That was sort of not part of this question, but I'll mention it because it's sort of related. If I get trademark protection with the USPTO and I decide that my business is going to do business in Spain or somewhere else, That's a whole different set of requirements to gain trademark protection internationally. So just kind of keep that in the back of your mind. For most businesses, that isn't relevant. Most businesses are focused in the United States, at least that are located in the United States. But what I want is that federal protection. That's the strongest protection, and it gives me protection in all 50 states. So if somebody in California launched a business confusingly similar to mine under a confusing name, if I've got a federal trademark registration, I could send a cease and desist to that business in California and say, please stop using my name. But there is a process by which you can get trademark protection within a single state. So one way is a way we've already talked about. If I open a restaurant in Chicago, as soon as I open my restaurant under whatever my name is, my brand, I now have trademark protection, common law trademark protection, which we mentioned before. And that protection will be what they call regional. It'll be only where I use the mark, which is in Chicago, if that's where my restaurant is. So in essence, that's like an Illinois trademark protection, right? I didn't do anything. I didn't file anything, but I'm getting trademark protection in Illinois. If a restaurant were to open in Utah under a similar name, and all I've got is my common law trademark protection, there's a good chance that I couldn't make them stop, right? Because I don't have protection in Utah because I'm not operating in Utah. My restaurant's just in Illinois. They're operating in Salt Lake City. No confusion. I don't have trademark protection over there unless I were to get federal protection by filing, as we talked about. There is a process by which you can file for state registered trademark protection. It's rare. You don't see many companies using it because most companies want protection across the United States rather just in their state. This restaurant could file for protection for just the state of Illinois. When might you do that? Well, one of the requirements, and we didn't get too deep into the weeds about all of the requirements to get federal trademark protection because it would be we'd be talking to you for hours and hours. You have to be not only operating in commerce, but across state lines, right? If my business is just in the state of Illinois and it never crosses the border to get into any other state, at least in theory, I'm not entitled to federal trademark protection. Now, there's companies that'll try for it even when they're only operating in one location and they're not crossing state borders. But in that case, if I only really cared about the state of Illinois, I don't care if a restaurant opens in Wisconsin or Iowa or Minnesota under a similar name, and I don't think I could get federal trademark protection because I'm not operating anywhere else, maybe then I would file for protection just in the state of Illinois for Illinois trademark protection. But again, that's the exception rather than the rule. There are far more federal applications with the USPTO for protection across the country than you see in a given state for sort of state limited protection. And with that, I'll give it back to Esther. Maybe one more. I think we're sort of at time at this point.
Instead of answering a question, I'm just going to, at one point, I just want to make sure everybody leaves with federal trademark protection is first to file. So even if you were using the mark first and you don't file with the USPTO and someone in another state files they copy off of you, those jerks. If they file first, they can stop you from expanding outside of Illinois. So really thinking about trademark protection early on, first to file. And with that, I think we are out of time. This was such a pleasure. Awesome questions, really some of the best questions that we've seen and we do this seminar, this workshop all the time. These questions were fabulous. And we hope it was helpful to all of you. And if you want to review anything we said, like we mentioned earlier, I think this recording is going to be available. And also we put another recording of this workshop in the chat as well.
And I just want to reiterate what Esther said. It was a pleasure speaking with you. Questions were fantastic. And I just want to remind you all, we love working with companies that attend these types of sessions. You're all presumably entrepreneurial in spirit. And so do look at the link that Esther posted to the DPLC clinic. Again, we're finishing a semester and then we're entering the summer, but in the fall, we're going to take on a new sort of cohort of clients. And if you've got a business and you're looking to do some of the things that we do in the DPLC, please do apply. And if we have the capacity, it's always a capacity issue, maybe we can work with some of your businesses.
And just additional plug, we don't charge for our services. So it's really, we hope it's a value for our clients, but it's also such a value for our students to get the experience of getting to work with real businesses, that we like to think it's a win-win. So we appreciate when clients are willing to work with us and work with our students. And in return, we do our services pro bono. So
And so
hopefully,
you can't complain about our fees. That's
I mean, you can, but
that's not fair. We don't charge any, so we can't have any of those complaints. That's the deal.
awesome. Well, thanks again. And hopefully we'll see some of you in the near future.
Thanks, everyone. Bye-bye.
Bye.
Thank you.